Good day. Welcome to episode 5 of our channel. For this video, we will be discussing Community Service Act. You will encounter this in Criminal Law 1, particularly in execution and service of sentence. And also, this topic is part of the 2026 Bar Exam Syllabus. So under this topic, we will be discussing Republic Act number 11362, or the Community Service Act, and AM number 20-06-14-SC, or the guidelines in the imposition of community service in lieu of imprisonment. So to begin with, what is community service? Under the law, it consists of any actual physical activity which inculcates civic consciousness and is intended towards the improvement of a public work or promotion of a public service. So as to the applicability of this law, the penalties of arresto menor and arresto mayor may be served by the defendant by rendering community service in the place where the crime was committed in lieu of jail time. So once an accused is found guilty of a crime punishable by arresto menor or arresto mayor, then instead of jail time, the accused may apply for the may avail of this law and render community service instead of being imprisoned. So what are the terms of community service? It is the court who shall determine the terms of community service, and the defendant, if admitted, shall be under the supervision of a probation officer. And in case the accused violated any of the terms of community service, then the court shall order his or her rearrest, and the defendant shall serve the full term of the penalty, meaning makukulong siya. So what is the a period of community service under the law? It should not be more than the maximum sentence imposed by law, but not less than 1/3 thereof. As to its the termination of community service and the discharge of the defendant under the law, after the period of community service and upon consideration of the report and recommendation of the probation officer and SWDO, the court may order the final discharge of the accused upon finding that he or she has fulfilled the terms and conditions of his community service, and thereupon the case is deemed terminated. So similar with probation, the termination of community service is not automatic. It requires an order from the court. What are the limitations in availing community service? Number one, the privilege of rendering community service in lieu of service in jail shall be availed only once. Okay? And appeal of conviction bars application for probation or community service. So remember these two limitations. But what will happen if this is the case? If the accused is sentenced with a penalty a penalty higher than arresto menor or arresto mayor, meaning he could not avail of community service, and on appeal, the penalty was lowered to arresto menor or arresto mayor, which became final and executory, then the accused may, upon written application with the court of origin, seek community service in lieu of imprisonment, which may be acted upon subject to the provisions of these guidelines. This is similar with probation. And if you have read the case of Colinares, this is similar. The logic of this rule is likewise based on that ruling by the Supreme Court. However, it is also stated that with respect hereto, in no case shall community service be allowed if the defendant is a habitual delinquent. Okay? So this happens, for example, the accused is convicted of attempted homicide by the uh, uh, by the trial court, and then on appeal, uh, it was held that the accused has no intent to kill, and the court ruled that the crime or that the accused is only guilty of slight physical injuries. Then, in that instance, even though the accused has already appealed the conviction of attempted homicide, since community service is not yet available that time, then upon the modification of the ruling and conviction of slight physical injuries, then the accused may now apply for community service. So that's the application of this rule found in AM number 20-06-14-SE. In the event that the court denies the application for community service and the period to appeal has not yet lapsed, then the accused may still choose to appeal the said judgment or apply for probation. So pag na-deny siya and then may period pa to appeal or apply for probation, then the accused may be allowed to do so. And finally, an accused who has applied and was granted probation in a previous case is not disqualified to apply for community service in a subsequent case. It may happen that before the accused has a case where he was convicted, and then he applied for probation. Thereafter, he was again charged with a crime and convicted. Then the fact that he was applied and granted probation then will not disqualify him or her to apply for community service in the next case, which was likewise found guilty or where he was actually convicted. So these are the salient features of the law. Hope you remember them, and I hope this video is helpful in studying Community Service Act. Thank you.